God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session at the 5th District Court of Appeal. As announced, I'm Alan Lawson. I'll be presiding this morning. To my right, Judge Sawaya. To my left, Judge Edwards. We have, for the first, we're going to take a break after the first three cases. We have three cases before the break. One is criminal. As you know, you have 15 minutes per side. And for the civil cases, it's 20 minutes per side. If you are the appellant, there are no cross appeals. So if you're the appellant and want to reserve time for rebuttal, let me know how much and I'll set it so that the yellow light comes on when you're in your rebuttal time. First case is Kenneth Earl Jackson versus State of Florida. And who's going to argue? Mr. Pinnell?
Good morning. May it please the court. My name is William Pinnell and I represent the appellant Kenneth Jackson in this case. Please reserve 4 minutes of my time for rebuttal.
Okay.
A defendant is entitled to a fair trial pursuant to the Florida and United States constitutions, and Mr. Jackson was denied of a fair trial based on multiple errors in the jury instructions on self-defense, which was his sole defense, based on improper closing argument by the prosecutor, and because he was provided ineffective assistance of trial counsel that is clear on the face of this record. Based on these errors, it's impossible to have confidence in the outcome of the trial, and this court should reverse Mr. Jackson's convictions and sentence. I'm going to focus the majority of my time on issue 2, certainly willing to answer any questions the court has about the other issues, but it's our contention that the instruction on the justifiable use of non-deadly force improperly informed the jury that Mr. Jackson could only use non-deadly force if he believed he was in danger of death or great bodily harm, and that's an incorrect statement of the law. Certainly that was in place at the time of his trial, and that continues to be in place today. The state, in its brief, conceded that the instruction was an erroneous statement of law.
Yeah, you've got to show that it was fundamental error because it wasn't objected to, right?
I do.
Okay, so why is it fundamental error?
It's fundamental error first and primarily because the state used the instruction against Mr. Jackson in closing. In closing argument, they relied on the erroneous instruction by reading it and then indicating if a defendant was not engaged in an unlawful act and was attacked in a place where he had a right to be, he had no duty to retreat and the right to stand his ground and meet force with force, including deadly force, if he reasonably believed it was necessary to do so to prevent death or great bodily harm to himself. And it's the last part, the reasonable belief it was necessary to prevent death or great bodily harm to himself. That's a misstatement of law. Immediately following the prosecutor...
Did I read that the legislature has since amended the statute to add that comma to set off, including non-deadly force?
They've amended both 776.012 and 776.013. And now in 776.012, it indicates explicitly when using non-deadly force, you have no duty to retreat. And so that cures and they also amended subsection 3 of 776.013, subsection 3, which had this comma, and they changed it completely.
Okay.
So it hasn't been amended to say that this instruction is correct. It's been amended to clarify the law to indicate that a defendant in Mr. Jackson's position does not have a duty to retreat and can use non-deadly force in response to non-deadly force.
This wasn't addressed really in the briefs, and I didn't check the record on it, but was the jury instructed on how the use of a gun, as a matter of law, if you do not discharge a firearm, it is non-deadly force, correct? And as a matter of law, if you discharge the firearm, it's the use of deadly force, correct? Was the jury told that simply pointing a firearm at someone is non-deadly force as a matter of law?
They were not. They were given a general definition of non-deadly force and a definition of deadly weapon. They weren't told specifically, from my reading of the record, what the court just indicated, that a firearm being discharged as a matter of law is deadly force, and if it's not, it's non-deadly. They were not given that clear distinction.
Okay.
So immediately after the prosecutor read the improper instruction, the prosecutor argued, ladies and gentlemen, there was absolutely no testimony here that at any point in time did the defendant feel that the victim's actions would cause death or great bodily harm. Quite the opposite. Mr. Sagaya had told you that he had no weapons, he had no guns, he had nothing. So they took advantage of the improper instruction in closing argument, and that's the important distinction the cases that have decided this issue have made. The Talley case and the Martin case both indicated it was fundamental error because the prosecutor took advantage of the improper instruction in closing. The Sims case and the Neal case, which the state relies on, that was not the case. So that's the important distinction, and that's why we have fundamental error here.
If you read the jury instructions as a whole, I think the court in Sims, the first district in Sims says you read the jury instructions as a whole. And they found that when you do that, in that particular case, it was not fundamental error.
I don't think that's the case here, because the jury is told that Mr. Jackson needed to have a reasonable fear of death or great bodily harm before he could use non-deadly
You're saying
force.
the distinguishing feature in this case is that the state relied on the error in their closing argument?
There's that, and the problem is we have a credibility contest here. We have Mr. Jackson and Mr. Sagaya's disputing accounts of what happened here. Under this instruction, they could believe Mr. Jackson and still find him guilty because they were misled by the instruction. Because again, they're told that non-deadly force can only be used if he has fear of death or great bodily harm. That's the harm here. That's the prejudice to Mr. Jackson, because you have a credibility contest, and even if they believe what he said, and under the law what he said would be lawful, under the instruction they're given, the jury's told they can still find him guilty. And that's why it's fundamental error, in addition to the fact that the state used it against Mr. Jackson in closing.
Does the attorney correct the state's argument and say that's not correct, and this is the way you should look at it and view the jury instruction?
I don't believe she did, Your Honor. I think she argued that he was credible, but I don't think she correctly argued it, and I don't think the argument either way would cure the improper instruction.
Another factor that the courts consider is whether the written instructions, which are erroneous, are given to the jury, and they were in this case, correct?
Correct. So it's our position that the Martin case and the Talley case control here. For some reason, the state didn't seek to refute the Martin case in their brief. It's our contention that's because it's indistinguishable from the facts of our case. And that the Sims case doesn't apply because in that case, the district court found that 776.013 didn't apply because the defendant in that case was actually trespassing and engaged in unlawful activity. So that took it out of the realm of the Martin and Talley decisions. And of course, there's no evidence that Mr. Jackson was committing any crime. He was actually in his own residence waiting for movers. He was not a trespasser or committing any offense at the time of this altercation. So the Sims case doesn't apply, and the Neal case, which the state has filed as supplemental authority, essentially relies on the Sims case. And again, for the reasons I've stated, Talley and Martin are the controlling decisions in this case. So it's our contention that there's fundamental error. It was relied on by the state. It negated Mr. Jackson's sole defense because the jury could believe what he said and still find him guilty based on the misleading instruction. And the court should reverse his convictions for that reason. Additionally, the instruction improperly informed the jury that there must be an injury to the alleged victim before self-defense would apply. And because neither of the offenses for which Mr. Jackson was convicted requires proof of injury, it's our contention that's also erroneous and requires reversal of Mr. Jackson's convictions.
All the cases that say that are from the 4th District, correct?
There's one first DCA decision, I believe, Your Honor. And then this court addressed it, I think Your Honor addressed it in a concurrence, where they said the defense counsel actually provided the instruction to the trial court, and that was the reason for the affirmance, but said it could be raised as a claim of ineffective assistance of counsel. So, and that's not the case here. The trial judge is the one that created the instructions. She certainly went over them with the attorneys, but she's the one that determined what portions to put in and printed them out. It was not like a situation that was present in the case which this court addressed. Next, the instruction was erroneous. The justified use of non-deadly force instruction was erroneous because it placed a burden of proof on Mr. Jackson.
Let me ask you this, the cases that are cited as to each of the 5 issues on appeal all analyze each issue independently, but in light of the entire record. I mean, you look at fundamental error in light of the entire record. To what extent do you look at the cumulative effect or combined effect of all errors?
Well, I certainly think the court should look at the cumulative effect. I think you have multiple errors in the instructions. I think you have an error in closing argument where the prosecutor misstates the law as to that just simply pointing a firearm at someone is deadly force. The state concedes that in their briefs. So we know the state has conceded that the instruction requiring fear of death or
If you
great...
look at them individually, are you basically saying that the misplaced comma is your strongest argument?
I do believe issue 2 is our strongest argument, Your Honor. I think they're all valid and support reversal, but I think issue 2 is the strongest argument, and I also think the totality of the circumstances supports a reversal in this case because of the numerous errors in the instruction and the improper argument by the state in closing, which the state has conceded. I'll go ahead. If the court has no question, I'll reserve the rest of my time for rebuttal.
Okay, thanks.
May it please the court, my name is Chris Davenport and I represent the state of Florida. First of all, let me just clarify the deadly force with the gun thing. As a matter of law, if you discharge a firearm, it's deadly force. But you can still use a gun without firing it in a manner that's deadly force. You can beat somebody to death with a gun, and that would be deadly force.
Okay, but if you just pointed at someone as a matter of law, it's not deadly force.
Right. Well, no. Yeah, I would agree with that, because you're just pointing
I
it.
mean, if you strike
Yes.
them with it, it's like
If you
any
strike
other
him with it, which is what he did here. I mean, he also hit him with the gun, and, the jury could find that that was deadly force.
The prosecutor was arguing that by pointing the gun at him.
The prosecutor made a single statement in closing argument about that, and then went on to say, and he beat him with the gun, which could be deadly force, and that was the state's argument. He did make a misstatement
also
along.
argue that you can't find self-defense because there was the use of deadly force.
The prosecutor, the main gist of his argument was, it's a battle of victim versus defendant. Whose story do you believe? The victim's more credible, it's supported by all the other evidence, stuff like that. And he said that the defendant used deadly force. He beat him over the head with the gun, and that was deadly force. They were not instructed on unjustifiable use of deadly force. The trial counsel made a decision to not request that instruction. We don't know why. It's argued now that that was ineffective assistance on its face, but they talked about it at the charge conference, and she changed her mind. So we don't know why. Maybe she didn't believe that this was deadly force and didn't want that instruction given to the jury because she wanted to focus him on non-deadly force. We don't know. That's why you have a hearing, is to ask her why she did that.
That sort of is, it's the combination of errors that really concerns me. You have...
Right.
Yeah, I mean, I think a layperson is going to think that if you point a gun at somebody, that's deadly force. I mean, because a gun is a deadly weapon. And they're told, a gun
Well,
is-
but they're also, yeah, it was one statement, but it was one...
That's the law. They were told that it is deadly force, and that makes common sense.
Well, the prosecutor argued that one time. It was one sentence in a decently lengthy closing argument, and he also hit him over the head with a gun, which could be deadly
defense
force.
counsel who, knowing that just pointing a gun at somebody is not deadly force, and with the stipulation that there was no great bodily harm, which shouldn't have anything to do with it, decides not to ask for the deadly force instruction. So you have the prosecutor misstating the law, saying it's deadly force to point the gun, which the jury probably accepts, because, I mean, it makes sense. And then you have no deadly force instruction, and then the jury's told that you can't use non-deadly force if, unless deadly force is used against you. I mean, that combination of errors makes it hard to wonder how this jury could have understood the law
There is a
correctly.
bit of a combination of errors, but let me note, a combination of unobjected to errors.
Right.
Not once
See,
did
that's
trial
the
counsel
issue
say,
that- Or if you take one individually, do they constitute fundamental error? Then you take them all collectively, is that fundamental error?
and we would
That's
submit
what
it's not.
the main concern is.
I would note, my timer is not going,
Look
just,
at- Oh, you know what? I was so interested in seeing what you...
Let me say this, just more globally. It seems to me that courts have gone far afield when we're saying that it's fundamentally erroneous because there's a comma in a written jury instruction.
But the comma, but the one misplaced comma can change the total meaning of a sentence.
Absolutely, it can, and you have to go through these instructions with a fine-tooth comb
Yeah, but
to
that's
find
not-
a comma.
But their primary argument is that the prosecutor argued it that way to the
Well,
jury.
right, and it
And
seems
so
like
that-
there's two sets of cases. Sometimes they find it
I mean, I
fundamental,
agree
or
with you.
sometimes they
If it's
don't.
just the comma, looking at the totality of a trial.
Right.
You know, it's hard to see fundamental error in most cases, I would think, although courts have found it in some.
Courts have found it in some, and let me...
But let me just ask you.
Okay.
You would agree that you look at the entire trial when
You-
determining fundamental error?
Yes, you look at all of it.
It's hard to say, I mean, it's hard to have confidence in the outcome when you combine all the errors that we have in this case, including counsel's error and not addressing, I mean...
Well, but again, counsel's error is in not objecting to the prosecutor's argument when it could have been easily corrected. Why didn't she object? I don't know. Maybe she doesn't like to interrupt. Maybe she was going to use that against them. You know, in defense counsel's argument, she said, of course he had a fear of great bodily harm. Movers carry box cutters. There's 3 guys here. He's in a strange city. It's nighttime. This was obviously a very antagonistic relationship that they had going here. You know, she argued that, of course, he feared great bodily harm.
If the jury believes that pointing a firearm is deadly force, the prosecutor told them that, and it sort of makes sense. If the jury read the instructions that they had and heard them correctly and understood that you had to, if you used deadly force had to be used against you in order to use non-deadly force. That was the comma error, correct?
That was the comma error, and I would
And
submit
if
that it's
they were
pretty
never
much a
even
stretch to believe that that's how they would take that. But, I mean, if you diagram the
And if they were
sentence,
never
that's correct.
instructed on the use of deadly
Deadly
force,
force.
so they didn't, they thought that the defendant could only use non-deadly force.
Right. But
Tell me how I should have confidence in the outcome of the trial in light of that combination of it.
because they were told what non-deadly force is. A non-deadly force is a force not likely to cause death or great bodily harm. So they were instructed on that correctly.
For me to have confidence, I have to be convinced to what level that they would have believed this to be non-deadly force.
Well, defense counsel, nobody argued that if you believe the defendant's story, he still couldn't use self-defense. Nobody argued that. What the argument was the defendant's story is just not believable. The victim's story is supported by all the other facts, and that's the one you should believe. Now, the state mentioned this erroneous comma instruction in passing, and they used it incorrectly. But I would submit there's a difference between mentioning it and relying on it. And if their main argument was, go ahead and believe him, he still didn't believe that he was going to suffer death from this old mover, this little mover. If that would have been the state's argument and that was the gist of it, then I would agree that this comma thing would be more troubling. I would still submit, we're talking about a comma here. In a written instruction, we don't know how the pause was made in the oral instructions. Yeah, they had written instructions. Did they go over the written instructions with such a fine-tooth comb because it's mentioned in passing? I would submit they didn't, because the self-defense instruction is like 4 pages. I mean, and it goes back and forth, and it has all of this stuff in it, and we're talking about a comma in one sentence. And again, if that was the argument at trial, if the disputed fact was, we all agree what happened here, the only disagreement is, was he justified in using the amount of force he used? And that is the case in some cases. That's what we fight about. Everybody agrees with what happens, but it's whether he was justified. That wasn't what happened here. What the argument here was whose story do you believe? Do you believe the victim who said that he was just trying to get out of there? Do you believe the defendant who said the victim came at him, grabbed him in the face, covered his eyes, there were 3 movers there, it's the middle of the night, and he's a little fearful being in a new city anyway, so he pulled his gun and smacked him on the head to get him off of him. If you believe that, nobody argued you can believe that and still find him guilty. What they said was that's not believable.
The word injury, the first argument, you correctly point out that there was an injury.
Right.
In connection with the battery offense, right?
Right.
There was no injury connected with the assault offense, correct?
There was no, right, because you don't need an injury for an assault, yeah.
What about, and nobody's raised it, but what about, I mean, every jury I've ever seen is instructed that you have to look at each crime charged individually and the evidence related to that crime. You separate them, you don't
Right.
put them in combination. How does that affect your argument on the injury issue with respect to the more serious charge, the one that carries the
Right.
dead man in the long prison sentence?
I would say because they weren't given 2 different self-defense instructions. They were read the 2 charges and then the 1 self-defense instruction. So I would think that the jury would apply that, more to both of them. And I would think a reasonable person would feel like having a gun pointed at him, I'm going to blast your head off, is an injury, not in the sense of a physical bleeding injury, but in the sense of a fearful, oh my gosh, this is traumatizing to me injury. Again, there was no specific instruction on that, but especially because nobody mentioned that as a reason to not allow him to be found not guilty. If the prosecutor had argued that, as he did in the cases where they found fundamental error, and there was no injury at all, I could see where the jury would focus on that and say, well, what's going on here? But it was just such a non-issue below. And again, easily corrected if defense counsel had just objected. And on appeal, defense counsel now is going through these jury instructions so carefully and finding all of these things, but everything is fundamental error. They should be going through the jury instructions carefully at the trial level. That's one of the defense counsel's jobs. You're supposed to object to instructions at a time when it can be fixed.
Given the incidence of reversals for fundamental error in self-defense cases, you would think that the state would also have a big interest in going through the jury instructions.
Ideally, they would, yes, Your Honor, that's very true. But, it's not the state's job to object. It is the trial counsel's job to object. And I would just say, from a bigger picture here, the fact that all of these things were not preserved below, and he has case law to support every claim, I would just say that fundamental error is getting out of control in these jury instructions. And I think the courts need to be a little bit more realistic about, a 3-page self-defense instruction, finding fundamental error in a comma, unless it's relied upon, unless that's the issue.
Do you think that proves his case of ineffective assistance of counsel?
I think that he could certainly raise that claim and say, more troubling is, why didn't you request deadly force? Because there's certainly an argument that smacking somebody 3 times with a gun, pistol whipping him, could be deadly force. And I would be interested in her answer. I wish we could ask that, but we can't. That's why you have hearings at the trial court. So there's certainly a hearing deserved 3850 should he choose to pursue that remedy. But again, ineffective on the face of the record, I don't think so, because it's clear that she did consider it and rejected it for whatever reason. It'd be interesting to know why. So that's my position on that. And yeah, there's a lot of little things wrong here.
How could it not be ineffective assistance if there is a valid argument that deadly force was used by your client?
Because she might have made a strategy decision to say, I didn't want any focus on deadly force, I wanted the focus to be on non-deadly force. And look, we're talking about a gash in his head.
When the prosecutor says pointed a gun at somebody's deadly force? You know,
Again, interesting question to ask her at a hearing. Perhaps she saw the jury shaking their head or rolling their eyes. I mean, we don't know that on a cold record. It could be a strategy. I would be interested in her responses, but the point is, we need her responses. It's not ineffective assistance of counsel on the face of the record, which is a very difficult standard to meet. So, you know, all of these little problems, I would submit, you know, 5 times 0 is still 0, because, you know, it wasn't when you look at the instructions as a whole and the record as a whole, and what was really the gist of what they were disputing
We don't
here.
have zeros. We have,
Point
because you're
zero zero
you're
one.
admitting errors. They're errors. The question, so we're adding errors or multiplying errors.
We're
The question is,
multiplying errors.
At what point do those multiple errors shake your confidence in the outcome of the trial?
When you look at the overall record and decide it made a difference, that he didn't get a fair trial. And I would submit, under these specific facts, because of what they were fighting about, because nobody ever said, go ahead and believe the defendant, but it wasn't the justified use of deadly force. That was, or non-deadly force, either one. It wasn't justified. It was, his story doesn't make sense. His story is contrary to the testimony of all these other people. That's what they were fighting about, was that dispute of fact,
Well,
not the
all
dispute
these
of
other
law.
people, there were only 2 people in the room when the force was used.
Right, but yeah, I mean, somebody heard him screaming. When the police officers got there, he was still waving his gun around. Things like that, you know, little things add up to, gee, this defendant is not making a whole lot of sense. Because he said, he got on the stand, and, you know, his 911 call was different from his trial testimony, but he got on the stand and said, you know, I swung the gun to get him off of me because he was pushing me in the face, which is very justifiable. I swung the gun, and then I looked and I saw his head was bleeding, so I backed off. Well, when the police officers got there, he's waving his gun around still, all agitated. So does that support the state's case that the defendant was really, really angry at these movers? Or does it support the defense claim that, you know, I was afraid and just needed him to back off? And, you know, waving
Probably
the
out of
gun
time, we
around.
won't know for sure.
Probably out of time. So we submit he did get a fair trial, and we would ask you to affirm. Thank you.
very much.
May it please the court. First, I'd submit that the court cannot have confidence in the outcome of this trial based on the variety of errors that were made in the instructions by defense counsel at trial and by the prosecutor's improper closing argument. I would point out this court's decision in Yee from 2013, where it says the trial court has a duty to ensure that the jury is properly instructed, and that duty cannot be advocated. So the trial judge also has a responsibility to make sure that there's proper instructions. This isn't the first time this has come up. The Talley decision came out in 2013, almost a year before Mr. Jackson's trial. So the trial court certainly had a duty to make sure there was a proper instruction, and did not do so. Secondly, the state's argument that the prosecutor did not explicitly rely on the comma and language after that is simply refuted by the record. If you look at page
It
290...
says it with one sentence, a reference in one sentence. Is that right? In the closing argument, just one sentence.
I disagree. I think there's several sentences, a whole paragraph where on page 299 of the record of the trial transcript, page 299, there's 3 sentences where following the prosecutor reciting the instruction, the incorrect instruction, a whole paragraph arguing that there's no evidence that Mr. Jackson feared great bodily harm or death. So there's a whole paragraph that emphasizes the incorrect instruction.
The sentence was pointed a gun at somebody as deadly force. That was the sentence.
Correct. Okay. I was talking about the other error. Sure. The argument, it's clear on the face of the record that trial counsel was ineffective for failing to request justifiable use of deadly force. There's no valid or reasonable strategic decision to do so. She essentially waived the defense that Mr. Jackson had and allowed the prosecutor to exploit that during closing without objection. So it's unreasonable, and there's no reason for an evidentiary hearing because there's no valid strategic decision to do so. The state's argument that, well, it's just a comma and the jury has to look at it, you know, when I'm arguing improper closing argument, we're always told that, well, the jury was properly instructed. We need to assume that the jury read the instructions and understood what they were told, otherwise the system doesn't work. So they were told that he could not use non-deadly force unless he feared great bodily harm or death, in writing and orally. And there's no reason to believe they didn't follow the instructions as they were given. And the tally court in the second DCA said, just because one part of the instruction is correct doesn't mean that excuses the other part, because we can't assume the jury is going to figure out which one's right. So the fact that they were given a half an instruction that was correct and the second part was incorrect doesn't cure the error here and doesn't make it not fundamental. But most importantly, and I'll end on this point, as the court said in Martin and in Talley, we have a credibility contest, as the court has pointed out. There's two people in the room, no other eyewitnesses, and it really comes down to which account the jury believes. The problem with that is, under the instruction they were provided, because they were misled in the instruction, they could believe Mr. Jackson and still find him guilty. That's why we have fundamental error, because the instruction allowed them to convict him improperly, even if they believed his testimony. So we'd ask the court to reverse his convictions and remand for a new trial. Thank you.
Very much. And I didn't announce this earlier.